am writing this today so everyone is aware of the huge impact Mauricio Powless has had on my family. We planned a little family getaway that weekend in January 2024 to get away from town, relax, and have a good family time. Well, it was anything but that. It was actually quite the opposite. It has been a little over a year since that day, and we still struggle emotionally, physically, and mentally. The way she screamed for help when it happened replays in my mind constantly. My son and daughter passed him in the hallway. He is the one who decided to turn around and follow them. Thank gosh their destination was to knock on our hotel room door where we were staying and where I was, because I was right there. I did chase him as I seen the staircase door closing, but he was already out of my sight. But to do what you did and tell my daughter he tells me you thought this was just hilarious. Why did you think any of this was okay? And a question I have is, what is next for this man to act upon after his short 3.5-year sentencing, if that's what he gets? Because he was just seeing what he could get away with. If this happened to your child, please ask yourself, would I be okay with this person going away for 3.5 years? Mauricio, you mentally messed up our innocent daughter over something you thought was funny. Going through 2 sexual assault cases at once right now, so it is very hard for her to concentrate on anything. My son was with her that night when she was sexually assaulted, so it also has impacted him greatly as he couldn't do anything to help. He felt helpless. Have both missed days of school because of it replaying back in their minds. Extremely afraid of men and boys now. She always has to be with me anywhere we go. She wakes up in the middle of the night sweating because of the playbacks in her head, crying, and refuses to be alone even at home. She sees her counselor weekly and sees someone with a sexual assault center in Marinette, Lacey, who we are very thankful for. They both help her very much. If she feels like she needs to get out of class for a while, she goes and visits her school counselor for as long as she needs. I also talk about her future and how to try to ease that trauma so she doesn't carry on with it when she's an adult and needs to go off to college on her own, wants to meet someone, get married, have children, etc. These are all things that she will now struggle with because of what happened, and that's a very big deal. She won't even use a public restroom alone anymore. Not only did Mauricio Powless do this once, not twice, but 3 times on 2 separate occasions a week apart, where he had time to think about what he had done and then come back and act upon it again. That's not someone caring about what they're doing. I am asking he get at least 4 years per child and a solid 10 years out. Another important note I wanted to say was I was told by 2 different men that sat with him in jail that he laughs and brags about what he did. 2 people found me on social media, didn't even know it was my daughter, told me about it. My daughter will forever suffer. She will learn to cope, but she will forever have it with her the rest of her life. At 13 years old, that is not fair. It isn't fair for any child. I also now have a huge fear of letting my children out of my sight even for a moment. He chose to go there that day and do that to young children, and then chose to go back a week later. Mauricio, during your first court hearing, your apology at the end cut me. You were crying and saying sorry. Sorry doesn't work. You don't get to apologize and you do not get to cry. You made that choice for yourself. Our girls did not have a choice. Our girls, like I said before, now have to carry this with them forever. These are young, innocent girls whose lives you've traumatized. No man, let alone anyone, should ever be touching children. To drive to a family water park and do it 3 times is crazy. So I'm asking for 4 years per child. And before I'm done speaking, I want to also make it a point to say that because of all this, I had to be here to speak on behalf of my daughter, to be her voice. While I miss her very first track meet that was out of town today. So instead of her having someone cheer her on in the stands, I am standing here instead, rooting for her in court while she is alone performing today. And that breaks my heart as well. Your Honor, thank you for giving me the opportunity for my voice to be heard, as I feel we haven't had much say in the legal process. It really is extremely important to me to have a say for my daughter and the other two victims who have to now suffer, as I feel 4 years in is not enough for sexually assaulting these young girls, one being my daughter, and at a family water park. Thank you for your time, Your Honor.
Thank you. Mr. Powless, is there anything you wanted to say before I issue the sentence?
Oh, yeah.
If you prepared something in writing, you can just read it, if you choose to do that. Can you pull the microphone closer, Attorney Kibba?
Alright, first I would like to apologize to the victims and the victims' families. I'd like to apologize to the court and my family for my behavior and conduct and misguided judgment in this case. I stand before you as a 19-year-old adult in full cooperation in this case. I humbly ask you to take into consideration the fact that I am so young and how this is going to affect my life for the rest of my life. I'm not asking to go unpunished. I can't undo the mistake I made. Your Honor, I'm asking for a chance to redeem myself and not sit half of my young adult life behind bars. I would like to thank the court for giving me the chance to speak, and thank you for your time and consideration.
Thank you. This is a case where Mr. Powless is convicted of a Class B felony, an attempted Class B felony in count 1, and a Class C felony in count 2. When the court issues a sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, the character of the defendant, and deterrence of others, and apply the Gallian sentencing factors to those sentencing objectives. It is fair to say that there are required punishments in this case. First and foremost, the lifetime sex offender registry requirement with the GPS device. That is a penalty in and of itself that'll have a lifelong impact on Mr. Powless. And then being convicted of felonies in and of themselves are a penalty as well. You lose constitutional rights just for being convicted of felonies. And then if you reoffend in the future, these convictions can be used to enhance the penalties on future convictions if you commit crimes in the future. The state and Mr. Powless are having a joint recommendation here today for 3.5 years of initial confinement plus 8 years of extended supervision. And then it is fair to note that the pre-sentence investigation writer from the Department of Corrections did recommend probation in this case, I think for 6 years on one count, 5 years on the other, with a long imposed and stayed prison sentence. It seemed like a lot of the reason for that was that there are additional penalties for Mr. Powless as a registered sex offender if he gets a prison sentence, but I think kind of as we're all recognizing here today, those additional requirements that he's going to have are appropriate because of the offense that he committed, and that's why everybody here is recommending a prison sentence. Nobody's recommending a probation sentence. The defendant right now is 19 years old here today. He does have no prior record. He has a high school level education. He does have a regular employment history that's described in the pre-sentence investigation. He took responsibility for the offenses by pleading no contest to 2 pretty serious felony charges. And the pre-sentence investigation writer, after interviewing him, did believe that he was remorseful for the offenses that he committed. He prepaid an amount of restitution to one of the victims. He does appear to have treatment needs for alcohol, THC, and probably mental health as well. And having been exposed to controlled substances as an unborn child, And I do think it's basically common knowledge that the brain is still developing when you are 18 years old. So those are some positive and particular things about Mr. Powless, but then the court also has to consider the nature of the offense in this case. I don't think there's anybody in the whole world that would look at the facts of this case and not say the behavior was horrendous. I mean, that's just on its face, it's disgusting behavior that the community doesn't have to tolerate, and again, that's why we're all recommending a prison sentence here today, because it is very horrendous behavior that took place in this case, and the nature of the offense is significant, and the negative impact on the victims and their families is enormous. Children are the most vulnerable people in our community. Even a 13-year-old relies on the adults in their lives and adults in the community for their safety, and you participated in violating that important trust that even an 18-year-old adult has to protect children in the community. At the time of the offense, you were 18 years old. The victims in the case were one 10-year-old and 3 13-year-old females. The victims were at a birthday party in one of the incidences, having fun with their family at a water park resort in the community, and the context that this case occurs in is a factor and is an aggravating factor in the court's analysis here today. So you're an 18-year-old going around the facility groping and basically terrifying children in the community who are present at this facility, and these aren't teenagers who are close in age to you. I think that these would be more like elementary school for the 10-year-old and middle school for the 13-year-old. So even the age difference between you and the victims is not close. I would not call it close. There's no mistaking that this was a victimization conduct on vulnerable individuals in the community. You committed the attempted sexual assault on January 20th, 2024, and then you didn't get caught, so you returned on January 25th, 2024 to do it again to another 13-year-old victim, and I have no doubt that you would have continued to do it if you weren't caught after that January 25th incident. And then even worse than that, this is the type of thing that spreads around the community, and maybe other people would be emboldened to go to places like this and commit the same type of offense because you were able to get away with it. So there is a significant need to deter this type of activity in the community. And while probably not a victim for Chapter 950 purposes, I think the business itself here is a victim on the case. The impact to their reputation for this business that I think carries itself out as a family-friendly, fun place to take your kids. Stories like this spreading around the community has a negative impact on the reputation of that business. So in that way, I do think that the business itself is a victim of the crime and an aggravating factor as well. There are victim impact statements submitted for each of the 4 victims in the case. Victim 1 submitted a victim impact statement as document 30. With that victim, you pulled down her pants, exposing her underwear to you, making it an attempted first-degree sexual assault of a child. That's why it's an attempt and not a completed act. And then you prevented her from leaving the elevator. She was 10 years old, and you did this to her. In the victim impact statement, she does not express, or it might be a representative of the victim, does not express a specific opinion on the penalty. However, the statement says that her only comfort is knowing that he is in jail, and her parent doesn't know how they are going to tell the victim when you are eventually released, and because she's clearly very scared of you. As to victim 2, she was 13 years old at the time, and you also prevented her from leaving the elevator, so I think that victim goes to count 2 that was dismissed but read in the false imprisonment. In the pre-sentence investigation, a representative of the victim gave a statement. This incident took place during her birthday, so this is the one that has this permanent traumatic scar on her soul forever because of this taking place during her birthday. She's been in counseling for months. Her father recommends a prison sentence, but he does have mercy on you. He says the sentence doesn't have to destroy the defendant's life. And then her mother wants the maximum penalty because of the repeat behavior that didn't stop until he was caught. So that's the mother of victim 2 actually recommending a maximum sentence. Victim 3 has victim impact statements that were submitted. She was 13 years old. She gave her or a representative gave a victim impact statement as document 37. You grabbed her buttocks twice while she was trying to get away from you. Her mother is the one that testified here today, and what stuck out, one of the things that I highlighted from her testimony, is that she's actually on the other side of the door listening to her daughter trying to get into the room, just to kind of highlight how significantly traumatizing that is for a whole family at that point. She's recommending 4 years confinement for each of the 3 victims of the sexual assaults. In the pre-sentence investigation, she gave a statement stating that there's ongoing counseling. She's afraid to be around men. She has fear of being alone. It's impacting her at school. And then in the PSI, the mom gives another recommendation of 6 years initial confinement plus 10 years of extended supervision. And then a lot of the things that she testified about here today and gave a statement on are consistent with those prior statements that highlighting that there's still a struggle mentally, emotionally, and physically in this family. Her words were that you messed up our daughter over something that you found funny. Her sibling was present and felt helpless to be able to stop what was going on. She's afraid to use public restrooms. And one thing that really the court was paying attention to was when the mother said, you had time to think about what you had done, and you still decided to return about 5-6 days later and do it again, which was your conscious choice in this case. And then as to victim 4, she was 13 years old at the time. There's a statement in the pre-sentence investigation from victim 4. You snuck up behind her and pinched her buttocks. She seems to be a person that is seems to be a special needs child, making it difficult for her to cope with the victimization, even with counseling. She frequently inquires about the defendant still being in jail, and she is now afraid of being in crowds of people. When you victimize someone in the community, you have to accept that victim as who they are. And this victim being of special needs, being a special needs child, I think is an aggravating factor that the court is going to consider here today. The mother in this case, for this victim, recommended 6 to 8 years prison. So the bottom line from hearing from all 4 of these victims or their representatives is that you changed the course of these child's lives. I mean, this is exactly the type of offense that could stay with somebody forever. They could ideally get treatment, maybe get past this for a year or 2, grow up to go to college, get a job, and then 30 years from now, some experience will happen to them in life that'll re-traumatize them, and they'll think about what happened to them when they were 10 and 13 years old. This is the type of offense that can re-traumatize somebody for the rest of their lives. So the impact in this case, the court certainly is considering as being potentially lifelong trauma for the victims in this case. The Victim Rights Amendment to the Constitution is Article 1, Section 9M, and the purpose of that amendment is to empower victims. It gives them a voice in the process, and Section I specifically gives them the right to be heard, specifically at sentencing. So that's what was presented here today when we first started. Normally I do give a lot of weight to joint recommendations. The lawyers are in a better place than the court to evaluate and understand a case. The lawyers get all of the police reports on the case, they're able to investigate, actually talk to witnesses and victims on the case, and the court is not. So that normally the lawyers are in the best place to evaluate and understand a case. But I think that this is a case where the victims and their families are in a much better place than even the lawyers in the room to understand this case. So when I analyze all of the sentencing objectives, I do think that all of the sentencing objectives do point to a much higher sentence than what is the joint recommendation here today. There is a need to protect the public from this type of activity. I mean, I've gone over the significant nature of the offense significantly at this point, and the need to deter individuals going to a family-friendly water park resort and groping 10-year-olds and 13-year-olds at a birthday party is significant, and the community needs to know that there's a significant penalty for that to deter other people from doing that. So deterrence is a very significant sentencing objective here today also. So when I consider all of those factors, the total sentence here today is going to be 10 years of initial confinement plus 10 years of extended supervision. That is going to be on each count concurrent. I think the maximum penalty does allow that. And then you do have to register as a sex offender for the rest of your life. $60 restitution to victim 3. I am going to give 1 year to submit any additional restitution. I think this is a case where there could be additional costs over a longer period of time if the victims choose to seek restitution. Compass evaluation, AODA assessment, follow through with all treatment recommendations, maintain absolute sobriety, no contact with victim 1, victim 2, victim 3, victim 4, or their families, no contact with anyone under the age of 18 unless prior approval is given by the Department of Corrections, comply with chaperone agreements and recommendations of the Department of Corrections. That does not apply to any biological children you may have, no contact with Tundra Lodge, participate in sex offender treatment, evaluations, and follow all treatment recommendations, participate in all assessments, evaluations, and treatment recommendations deemed appropriate by the Department of Corrections. You do have to pay the court costs, and then you do have to apply a DNA sample as well and pay the surcharge. There's 443 days credit on the sentence. Did the state agree with that?
Judge, no objection.
And then Attorney Kippa, anything to clarify?
No.
From the defense, or from the state, anything to clarify?
No, Your Honor. I will just want to supplement the record, and I don't know if I mentioned this, but part of the basis was in the joint recommendation, I think it's important, was to avoid having to put these girls through a trial as well. And that was an important factor that went into the analysis, wanting to avoid re-victimization and further causing your additional harm. So I think that's important here to note. That is a factor in this recommendation that was made. Thank you.
Yeah, the court did consider it by saying that he took responsibility for the offenses by pleading no contest. You do have the right to seek post-conviction relief, including assistance to the Public Defender's Office if you qualify. Otherwise, that is the sentence of the court.